Welcome to Real Estate School. Today we have for you Real Estate Exam Prep Questions Speed Round. Many questions that will help you on your state's real estate licensing exam. So let's get started. Value placed on property for property tax purposes by the tax assessor is known as A. Estimated value, B. Actual value, C. Appraised value, D. Assessed value. Our answer is going to be D. Assessed value. An assessed value is the dollar value assigned to a property to measure applicable taxes. Assessed valuation determines the value of a residence for tax purposes and takes comparable home sales and inspections into consideration. A broker does not have to prove that she was the procuring cause in order to collect a commission if her seller sells the property without her help because she has A. An option listing, B. An open listing, C. An exclusive right to sell listing, or D. An exclusive agency listing. The answer is C. An exclusive right to sell listing. In an exclusive right to sell listing, the listing broker receives a commission no matter who sells the listed property during the term of the listing. Brokers may have to prove that they were the procuring cause in some open listings and exclusive agency listing situations, but procuring cause is of no significance in an exclusive right to sell listing situation. Tina buys a cat and keeps it in her apartment, even though her apartment lease includes a clause that prohibits tenants from owning a pet. She does not remove the cat even after the landlord gives her a written reminder of the lease agreement and insists that she remove the pet from the apartment. Tina refuses, saying that the cat is very small and will cause no damage to the apartment. The landlord decides to remove Tina due to the breach of the lease agreement. The legal process to remove the tenant is known as A. Actual eviction, B. Eminent domain, C. Constructive eviction, or D. Partial eviction. The answer is A. Actual eviction. A tenant's breach of a lease can result in a court action known as actual or judicial eviction. Constructive eviction occurs when a tenant abandons the property because the landlord has breached the lease. Eminent domain is the government's power to take land for public use. A woman held fee simple title to a vacant lot adjacent to a business. She was persuaded to make the lot available to the business. She had her attorney prepare a deed that conveyed ownership of the lot to the business so long as it was used for commercial purposes. After the completion of the gift, the business will own A. A life estate, B. A tenancy for years, C. A periodic tenancy, D. A determinable fee estate. The answer is D. A determinable fee estate. The words so long as, or while or during, written into the granting clause creates a fee simple determinable that limits the use of the property for commercial purposes. The former owner retains a possibility of reverter. This is the person that ownership is going to revert back to if the condition is broken. A woman owns 50 acres of land with 500 feet of frontage on a desirable recreational lake. She wishes to subdivide the parcel into saleable lots, but she wants to retain control over the lake frontage while allowing lot owners to have access to the lake. Which of the following types of access rights would provide the greatest protection for a prospective lot purchaser? A. An appurtenant easement. B. An easement in gross. C. An easement by necessity. Or D. A license. The answer is A. An appurtenant easement. An appurtenant easement is annexed to the ownership of one parcel and allows the owner the use of the neighbor's land. The easement transfers with the title and so provides the greatest protection for a prospective purchaser. This is language that's written into the deed. If you own this lot, you have the right to use that access to the lake. It's part of ownership and would transfer with it, an appurtenant easement. Which of the following is not a test to identify a fixture? A. Intent of the parties. B. Method of attachment of the item. C. Size of the item. Or D. Adaptation of the item to the real estate. The answer is the size of the item, C. The overall test to identify a fixture is intent, which is determined by the method of attachment, adaptation to the real estate, or agreement of the parties. A man owned 2 acres of land. He sold 1 acre to a neighbor and reserved for himself an appurtenant easement over the neighbor's land for ingress and egress. The man's land is known as A. is the servient tenement. B. is the dominant tenement. C. can be cleared of the easement when the man sells the withheld acre to a third party. D. is subject to an easement in gross. The answer here is B. the dominant tenement. The man's parcel benefits from the easement and is the dominant tenement. The neighbor's tract over which the easement runs is the servient tenement. If an owner takes his property off the market for a definite period in exchange for some consideration, but grants an individual the right to purchase the property within that period for a stated price, this is called A. an option, B. a contract of sale, C. a right of first refusal, or D. an installment agreement. Our answer is A. an option. An option is granted when the owner gives the potential purchaser, the optionee, the right to purchase the property at a fixed price within a certain period of time. This is known as a unilateral contract. Only one party is bound. In this case, it would be the seller. 2 individuals own property as tenants in common. When one dies intestate, her interest passes to A. her heirs, B. the other party as a sole owner, C. her heirs with the other party as a joint tenant, or D. her heirs if the property is sold. The answer here simply is A. her heirs. Any interest as a tenant in common passes to the heirs, whether by will or by the law of descent and distribution, if the deceased did not have a will. Federal laws that have a significant impact on property management include all of the following, except A. the Mortgage Disclosure Improvement Act, MDIA, the Americans with Disability Act, ADA, the Equal Credit Opportunity Act, ECOA, or the Fair Housing Act. The answer is A, the Mortgage Disclosure Improvement Act. A property manager is not involved in a lender's disclosure requirements, but must be familiar with the Americans with Disability Act, the Equal Credit Opportunity Act, and the Fair Housing Act. The owner of a house wants to fence the yard for her dog. When the fence is erected, the fencing materials are converted to the real estate by A. Annexation, B. Severance, C. Immobility, D. Indestructibility. The answer is A. Annexation. Annexation is the opposite of severance. Personal property, originally the fence, is converted to real estate once it's permanently attached or annexed to the land. When receiving a gift of a parcel of real estate, one of the two new owners was given an undivided 60% share, and the other received an undivided 40% share. The new owners now hold title as A. Joint tenants, B. Community property owners, C. Tenants in common, or D. Cooperative owners. The answer is tenants in common. Tenants in common hold property with undivided fractional interest, and the shares do not have to be equal. In a joint tenancy, each owner holds equal shares and interest to the property. Community property consists of personal or real property acquired by either spouse in a marriage and belong to both parties to the marriage. In a cooperative, owners share in a corporation, partnership, or trust which owns the property, with each owner holding a proprietary lease and the right to occupy his or her unit. What type of estate is created when a property owner deeds a parcel of his property to a town for recreational purposes only? A. A leasehold estate, B. Fee simple absolute estate, C. Fee simple defeasible estate, or D. Life estate. The answer is C. Fee simple defeasible estate. Just like it sounds, an estate that can be defeated. The deed conveys a fee simple defeasible estate which includes a specific condition on the use of the parcel. If the town uses the parcel for any other purpose than for recreational use, the property owner can take possession of the property through legal action. Holders of a leasehold estate have no ownership, only possession. A fee simple absolute estate has no restrictions on the use of the property. A life estate is limited in duration to the life of the owner of the estate or the life of some other designated person or persons. A standard rectangular survey system section contains A. 36 townships, B. 640 acres, C. 160 government lots, or D. 160 acres. The answer is 640 acres, B. Each township contains 36 sections, and each section is 1 square mile or 640 acres. Which of the following clauses give a lender the right to demand the entire loan balance be due and payable upon the buyer's default? A. A defeasance clause, B. Alienation clause, C. Due on sale clause, or D. Acceleration clause. The answer is acceleration clause. The acceleration clause, or speed up, allows the lender to declare the entire loan balance due on the borrower's default. The alienation, or due on sale clause, allows the lender to accelerate the balance due if the borrowers alienate or sell the mortgage property. The defeasance clause requires the lender to release its lien claim against the property when the entire debt has been paid. Taxes levied on a property owner to pay for installations of sidewalks or sewers are called A. Ad valorem taxes, B. General property taxes, C. Special excise taxes, or D. special assessments? The answer is D, special assessments. Special assessments are taxes levied on real estate to fund public improvements. Which of the following describes a contract that has not been fully performed? A, voidable. B, unenforceable. C, executed. Or D, executory. The answer is executory. The phase from offer to a closed and executed closed contract is called the executory period. Voidable contracts are binding on one party and not the other. An unenforceable contract is valid but cannot be enforced in a court of law. Which of the following is an example of involuntary alienation? A, having a piece of land sold for delinquent taxes. B, selling a property to pay off debts. C, giving a piece of land to the zoo. Or D, letting another person plant crops on an unused portion of a piece of land. The answer is A, having a piece of land sold for delinquent taxes. Title to property transferred without the owner's consent, known as involuntary alienation, is usually carried out by operation of law and can include having the property sold to satisfy delinquent taxes or foreclosure of a mortgage loan. A real estate professional is helping a buyer and a seller fill out a sales contract but is not representing either party. The real estate professional is A, designated broker. B, a transactional broker. C, a traditional broker. Or D, an unlicensed broker. The answer is B, transactional broker. In a transactional brokerage, a real estate professional facilitates the transaction between a buyer and a seller, but does not represent either party and cannot negotiate for either party. The transactional broker must be licensed. Another term for this is non-agency, because the broker is not representing either party's interest. Both parties would be considered a customer. A tax lien on the property can hinder the sale of a property because it is A, a monetary charge that the purchaser must satisfy. B, an appurtenance that does not affect the title. C, an encumbrance. Or D, an encroachment. And the answer is C, an encumbrance. An encumbrance is a claim, charge, or liability that attaches to real estate. It is a right or an interest held by someone other than the fee owner of the property that affects title to the real estate. A man conveys the ownership of his house to his mother and stipulates that upon her death he will recapture ownership. The interest the man has in the property is A, remainder interest. B, a courtesy estate. B, a legal life estate. Or D, a revisionary interest. The answer is D, a revisionary interest. The man's future interest in the fee simple estate is called the revisionary interest because ownership will revert to the original owner when the life estate ends. As opposed to a remainder interest, this is where the creator has named somebody else other than themselves for ownership to return to upon the end of the measuring life. Tony's lease has expired, but he has not vacated the premises or negotiated a renewal lease. The landlord has declared that Tony is not to remain in the building. This situation is an example of A, an estate from period to period. B, a tenancy at sufferance. C, a tenancy at will. Or D, an estate for years. The answer is tenancy at sufferance. B. tenancy at sufferance occurs when a tenant who lawfully possessed real property continues in possession of the premises without the landlord's consent after the lease rights expire, typically from an estate for years. An estate from period to period automatically renews unless notice is given. A tenancy at will permits the tenant to possess property with the landlord's consent for an unspecified term. An estate for years is a leasehold estate that continues for a definite period, whether that period be days, weeks, months, or years, and has a definite expiration date. A developer grants a local power company the right to install necessary transmission lines. This right is an example of A license, B, an easement by prescription, C, an easement in gross, or D, a conditional use permit. The answer is C, an easement in gross. Utility easements are rights to use someone else's land and are called easements in gross. This is the most common type of easement that exists today. A house sold for $180,000 and the buyer obtained a mortgage loan for $120,000. The lender charged 2 discount points. The buyer would pay A, $1,200, B, $1,000, C, $2,400, or D, $1,800. The answer is C, $2,400. A point represents 1% of the loan amount, not the purchase price, the loan amount. Calculate what 2 points or 2% will be on the loan of $120,000. $120,000 times 0.02, or $2,400. The buyer of a house in a small subdivision will be the only owner of the property. This means that the house will be owned, A, in common with the other homeowners in the subdivision, B, jointly by the homeowners in the subdivision, C, in severalty by the owner, or D, as the personal property of the buyer. The answer is C, severalty by the buyer. Ownership of real property by a single individual is called ownership in severalty. A tenancy in common or joint tenancy means that there is ownership by more than one person. How many acres are in the property described as follows? The northwest quarter of the southwest quarter of the northeast quarter of section 16. A, 5 acres. B, 20 acres. C, 10 acres. Or D, 40 acres. We find the answer by multiplying the denominators in each fraction. A quarter of a quarter of a quarter. Or 4 times 4 times 4 equals 64. One section contains 640 acres. So we take our 640 acres in a section, we divide it by 64, and that tells us this piece of land is 10 acres. The type of deed in which the grantor defends the title back to its beginnings is A, general warranty deed, B, a trustee's deed, C, a quitclaim deed, or D, a special warranty deed. The answer is A, general warranty deed. The general warranty deed provides the greatest protection to the buyer because the grantor defends the title against both themselves and all those who previously held title to the land, back to its origins. The type of real estate ownership that is most all-inclusive is A, a life estate, B, a conditional fee estate, C, a fee simple estate, or D, a revisionary interest. And the answer is C, a fee simple estate, or we also know it as fee simple absolute. An estate in fee simple is the highest interest in real estate recognized by law. Fee simple ownership is absolute ownership. The holder is entitled to all rights to the property. And if you own a home, I would imagine you do have fee simple absolute ownership. At closing for a typical real estate transaction, prepaid homeowners association fees are a debit to the buyer, credit to the seller. B, credit to the buyer, debited to the seller. C, a credit to the seller only. Or D, a debit to the seller only. Our answer is going to be A debit to the buyer and a credit to the seller. Prepaid items are items that the seller has paid in advance and which will benefit the buyer. So the prepaid amount not used should be credited back to the seller and debited to the buyer. In this case, the sellers prepaid the homeowners association fees beyond closing, so the buyer will be reimbursing the seller at closing for the portion of the time that the buyer is going to live in the home that the seller had already paid for. In what way does a deed of trust differ from a mortgage? A, obligation of the borrower to repay the funds. B, redemption rights allowed after foreclosure. C, number of parties involved in the loan. Or D, time period permitted to cure a default. The answer is C, the number of parties involved in the loan. A deed of trust is a three-party instrument that conveys naked title to a third party, the trustee, normally an attorney, who holds the title on behalf of the lender, also known as the beneficiary. The borrower is the trustor. A mortgage is a two-part instrument between the mortgagor and the mortgagee. What type of lien arises as a result of a judgment, estate or inheritance taxes, decedent's debts, or federal taxes? A, specific. B, voluntary. C, equitable. Or D, general. The answer is D, general. Each creates a general lien, a claim against all the personal and real property of the debtor. Rights or privileges that are connected with real property are A, improvements, B, appurtenances, C, not conveyed with the real estate, or D, restricted to air and water rights. The answer is B, appurtenances. Appurtenances are rights or privileges associated with a property and generally conveyed with the sale. Fair housing laws allow exceptions for all of the following, except A, private clubs, B, religious organizations, C, retirement communities, or D, racial discrimination. The answer is D, racial discrimination. The case of Jones versus Mayer in 1968 upheld the Civil Rights Act of 1866 and prohibits racial discrimination without exception. Private clubs, religious organizations, and retirement communities are not exempt from the Fair Housing Law's prohibitions against housing discrimination based on race. A suburban home with 4 bedrooms and only 1 bathroom suffers from what condition? A, curable physical deterioration. B, incurable physical deterioration. C, external obsolescence. Or D, functional obsolescence. The answer is D, functional obsolescence. Because a 4-bedroom home would be expected to have more than 1 bathroom, a home that does not suffers from functional obsolescence. It is lacking in the usual amenities of properties of its size. The term improvements, when referring to real estate, include A, shrubberies, B, trees, C, lawns, or D, sidewalks. Well, the answer here is D, sidewalks. An improvement is an artificial thing attached to the land. A sidewalk is a man-made addition. Improvements are man-made items. What is the principal difference between an estate for years and an estate from period to period? A. An estate for years cannot be terminated. B. An estate from period to period must be in writing. C. An estate from period to period has no expiration date. D. An estate for years is a life estate. The answer is an estate from period to period has no expiration date. C. An estate from period to period, or periodic tenancy, does not have a specific expiration date as it's automatically renews until notice is given by the tenant or the landlord. An estate for years has specific beginning and ending dates. Neither estate is a life estate. Each can be terminated. Both an estate for years and an estate from period to period must be in writing to be enforceable. A father conveyed the family home to his daughter by will as a procuring estate for the life of her mother. If the daughter should die before the mother, who gains possession of the property? A. The remainderman. B. The mother. C. The father's other children. Or D. The daughter's heir. The answer is D. The daughter's heirs. A life estate based on the lifetime of a person other than the life tenant is called an estate procuring for the life of another. The daughter is the life tenant, but the measuring life is the mother. The daughter's heirs will inherit the daughter's life estate, but it will end when the mother dies. When the amortized payment of a mortgage remains constant over the period of the loan, but leaves an outstanding balance to be paid at the end, this payment is called A. A balloon payment, B. An escalation payment, C. An acceleration payment, or D. A satisfaction payment. The answer is A. A balloon payment. Typically, mortgages with balloon payments are used as a creative financing tool in which buyers plan to refinance the balance in 3 to 5 years with better terms than they can qualify for now. Well, thank you for watching Exam Prep Questions Speed Round, and hopefully we've answered some questions that you might see on your state's licensing exam. Remember to subscribe, like, and ring that bell below. That way we can notify you before we release our next video. Thank you.